The analysis now from Misty Marris, trial attorney, legal analyst, here with me in studio in New York. Misty, always good to see you. What would you say stood out about what we know what the court ruled, what the court said today? What stood out the most to you?
What stood out the most was, of course, it's a 9-0 ruling. So that's uncommon. And again, there was a little bit of difference between the opinions and how the court actually got there and whether or not they needed to go that extra step. So very clearly, the states cannot execute with respect to Article 14, Section 3, and that the justices in the majority went a step farther to say there actually has to be legislation.
Right. It was interesting to see that distinction when we saw it between the states and the Congress. Let me put two screens up here to read from it. Kelly went through a lot of this, but just to drive home the point so you can give us analysis. First of all, Supreme Court ruling here, we conclude that the states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. But to your point on this concurring opinion, let's focus on this for a moment, because what we read there was that today the majority goes beyond the necessities of this case to limit how Section 3 can bar an oath-breaking insurrectionist from becoming president. Although we agree Colorado cannot enforce Section 3, we protest the majority's effort to use this case to define the limits of federal enforcement of that provision. Pick that part up.
Yes, I thought it was interesting. So this relates to the argument that was made about whether or not this provision is self-executing.
Right.
Meaning, does Congress have to act? Congress have to put a procedure in place in order to actually enforce Article 14, Section 3. So now the three justices said, this is actually overreach. You didn't even have to go there. And by doing so, you've now eliminated any other means of enforcing this outside of congressional action and what that would look like. So they say it actually went so far as to protect Donald Trump. Amy Coney Barrett also agreed that the court did not have to go beyond deciding that the states did not have this power, but she didn't go so far as to say it was an effort to further protect Donald Trump. So,
and I guess what's interesting about that is she's a conservative justice.
Right. So, and she agreed that we don't need to go past the inquiry.
Right.
Once the states did not have that power, we don't need to go one step further, but the majority felt that they needed to put a process in place, and that power lies with Congress.
Okay, here's this falls into a political scope. Now, I'm not going to ask you any political questions, don't worry, I never do, but let's look at the calendar here for the Trump legal challenges, right? Because that's all, as I mentioned right in the open of the show, tomorrow's Super Tuesday, so we knew the ballot's already printed in Colorado anyway, but, you know, it's all done now, it'll be on the ballot. But then we start to think about the hush money trial in New York, the arguments on immunity, which Kelly just reported on, the classified documents case before the convention, and then maybe something in Fulton County. If you look at the timing of what they did here, right, within a month, I think the court acted, right, hearing the argument. So for the immunity case, maybe that's late May for a decision, and then you go to pretrial proceedings. I've seen some analysis that said then you might get a trial late September. Does that sound right for you?
It's possible. It would be an aggressive timeline. So the arguments on the immunity case before the Supreme Court are April 22nd. It could be an expedited ruling. That could be late May. It could be when the sessions end in June or July. Right. And so it really depends on that. And then what happens next? Well, is there immunity? If there is immunity, then we're done. Right.
We're assuming that Trump loses in that case when we say there would be a trial, right?
Right.
So let's just say he does. Let's say he loses on this immunity argument. The court takes it up but doesn't side with the former president. You think they could get to trial sometime in September with an election in November?
Possible. Unlikely.
Why is it unlikely?
Because of that timeline with the Supreme Court. That would be a very, very quick turnaround to get that decision and then get a very, very complicated federal trial into the court. Remember, it's been removed from the docket at this point.
Yes.
So we're kind of starting from the discovery process, the exchanges. There's a lot to do before actually going to trial.
That's the big one, right? In some ways, at least from a political point of view, I think it is. I mean, the hush money trial is one thing. There's a lot of analysis to suggest that, maybe that is political overreach. I've seen people say that, whereas the January 6th trial, the one that I'm referring to now, is the one that people are really looking at. So you're saying unlikely that we'll see that trial before
I'm going to make a prediction that we're not going to.
Not going to see it before the election?
Correct.
Because you used the word complicated a moment ago. Does that have something to do with it?
It's a very complicated case.
Why?
It's a conspiracy case. It's relating to a meeting of the minds. So we've seen other people charged in the context of January 6th. The case now is against Donald Trump and what his participation is, and is there a conspiracy? That's going to be a heavy lift for prosecutors and a complicated case for defense, and everybody wants to go into that trial prepared because everyone should have due process and have their day in court. And I think that this case is probably not going to happen before the election. I've been wrong before. I'm usually right.
Yeah, but if you're wrong this time, that's a big deal when you think about it. That is a really big deal because that would be voters making a decision not knowing how that would go. And if the former president wins election again, we pretty much know what would happen to the case, right?
Well, and that's one of the reasons to expedite it. So if the Supreme Court does an expedited decision and we get that in May, then there's a better chance of the fall. But it could be stretched out until June or early July. That's a different timeline.
All right.
Those 2 months make a big difference under these circumstances.
See if you're right on your predictions. But as you've already pointed out, you usually are. Misty, we love the confidence, and you're right. You usually are right. Good to see you, as always. Misty Marris.